quite difficult, but bear with us. We have a stellar panel with us today and who will be sharing their views on very interesting topic. The panel will be chaired by Honorable Justice J.K. Maheshwari. Justice Maheshwari is a judge of the Honorable Supreme Court of India. Justice Maheshwari, in his long and distinguished career, has served as an elected member of the State Bar Council of Madhya Pradesh and has been on the bench for close to 2 decades. While Madhya Pradesh is his parent High Court, he has also served as the Chief Justice of Andhra Pradesh High Court and Sikkim High Court before his elevation to the Supreme Court. With this, may I request Honorable Justice Maheshwari to please share his opening remarks for the session. Please, sir.
So I'm so sorry to interrupt, but we have to felicitate the honorable judges and the chairpersons. Okay.
Good afternoon, everyone. As we are looking forward, since morning, everyone is having a very tired day. So looking to this situation, but we have in a national conference, so its importance is more paramount, but at the same time, we cannot stop the clock, but how the time will run, we have to decide accordingly, and accordingly our panelists have agreed for the same, that we'll go in a panel, but with time limits. So now coming to this session is mediation in commercial matters under the Commercial Courts Act 2015. Certain focus areas have been specified therein. Prior to starting with the same, I welcome to all of you in this city of temple, Lord Jagannath. So, Jai Jagannath, and I will say in the mediation in the recent past has become a cornerstone of the dispute. We are discussing all these issues. Now when we are going, we have 4 focus areas, and those focus areas we decided to divide amongst all. For every focus area, I will put certain points which will be discussed by our panelists. They are well versed of those subjects. Coming to the first topic, pre-litigation mediation under Commercial Courts Act. If we look into this area, then while looking to the same, they will explain it. I will put a remark that the Patil Automation Private Limited versus Rakheja Engineers is the judgment on section 12A. When this judgment came, then the issue came, then mandatory pre-litigation required, otherwise what would be the recourse of pendency of the suit. Then it was further discussed because of the conundrum arise. When mediation says it must be a consent, 12A of the Commercial Courts Act says no, it should be a mandatory mediation. Then this arise, then 2 judgments, Yamini Manohar versus TKD Kirti, and this another is Dhanbad Fuels versus Union of India 2025. This is Justice Jamshed judgment. So this is the issue on the particular pre-litigation mediation. Then the next is coming to hybrid dispute resolution models, mediation, arbitration, arbitration, mediation, arbitration. So this is the hybrid mode as suggested. When we go to this, there are certain issues, our panelists would emphasize this. This why it has been thought it appropriate. When we go for any of the contract, we find either settlement or otherwise there would be a conciliation then arbitration. So this is one of the issue. So this is a settlement by way of mediation probably, or otherwise it will go to the arbitration. But even in the issue of neutrality and so many other confidentiality arises in those cases. So probably I think section 30 of the Arbitration Act specifies that arbitration, mediation and arbitration may be a better recourse for the perspective of the India. When we go to the online dispute resolution, which is a third focus area, then we look into, then Niti Aayog has issued a policy of ODIA policy plan of India 2021. This is, I am touching the issue, nothing more. Our panelist will emphasize of this. Then global perspective. Global perspective is global model, contemporary trends and innovations. Then hub of international trade and investment mediation. Then finally, I will put two things. How and what manner this mediation should be successful and what our role, mediator's role, and what is the mindsets of the people. Yesterday when I was here in the opening session, then the example was put about from the time of the Treta Yuga of Angad was sent for the purpose of mediation prior to starting Ram-Ravan Yuddha. Then thereafter Lord Krishna was visited for the purpose of prior to starting Mahabharata. I was taking that clue from that story. If we take that clue from that story, then we have to thought what are the circumstances in which the mediation which was proposed asking only 5 games for the purpose of the 5 villages for the purpose of Mahabharata was not succeeded. Then I feel there are certain situations wherein it has been done. Lord Krishna told Pandavas that this is a situation you decide. If actual interest was being served, the thought process of the Duryodhana was not like this, that he has to give it or not. It was his kingdom, he should not want to lose any of the things, and for on the even on the cost of war and to lose so many lives. So here is the point lies for the mediator to put the circumstances, how and what manner, and the mindset of a person by which can be changed. So now with this I invite my all mediators, my panelists. In addition, this Mediation Act Chapter 10, Brother Koshi probably will be addressing on that. So all these issues will be started, and if we say for India we have a rich history as I discussed for the mediation, and mandatory statutory framework is in process. Some of the provisions have been notified, some of the provisions of Mediation Act 23 has not been notified. So it will go ahead. Now the discussion on the topic on the focus areas probably may give the pivotal opportunity to everyone to think and understand and to apply in the field, because provisions may be there, but overall until the application a right perspective is there, we cannot reach to the goal. So this is we thought, and I further request to my all panelists, please don't go for pleasantries to anyone and go on the topic. Now I am giving to Mr. Singh.
Sir, thank you so much, sir, for the opening remarks. May I now move on to Honorable Justice D.K. Upadhyay, and echoing the sentiments of Delhi Bar, I can say that we are honored to have him as the Chief Justice of Delhi High Court. He's also a former Chief Justice of the Bombay High Court and also served as a judge of the Allahabad High Court. So, Section 12 has been extensively discussed today, and if I may ask you your thoughts, whether the Section 12A has been effective and been able to achieve its intended purpose, and if not, what can be done to improve it?
Honorable Chair and other dignitaries, Namaskar. Now Section 12A has already been discussed, and after this Patel automation matter, it is mandatory. Its mandatory nature has further been emphasized by the Supreme Court in those 2 judgments which Honorable Chair just recounted. So far as the my
Intentionally not discuss on the judgments. You discuss on the judgments.
But so far as my view about section 12A being mandatory is concerned, if mediation is to succeed, that needs to be made mandatory. Otherwise, perhaps the same litigation process will have to be followed by the parties even in commercial litigation matters. So that do works, and in one of the discussions in the earlier sessions, it was said that Delhi High Court IP rules makes it mandatory. So far as the IPR matters are concerned, our experience has been that at least 60 to 70% matters are being settled through the mediation, at least in Delhi High Court. So I would think that this should be made mandatory. It is already established. But what are the other issues? Now, this mediation process has to be viewed in the backdrop of the fact that the very ecosystem in our country of the arbitration is faced with a lot of stress, and therefore it has to be viewed in that light. Mediation has to go. Why mediation is not the issue? How mediation may be an issue which we need to discuss. The legislature has already come up with a statutory framework. It's only that the provisions are to be implemented, they are to be notified. And if you see section 12A, the mandatory pre-litigation mediation is to be done by two types of mediators. Number one, of course, the Legal Services Authority, and it also talks about mediation service providers. So where are those mediation service providers? Number one. So as was said earlier in one of the earlier sessions, that we need a battery of, rather an army of mediators. That is true if mediation has to succeed. But at the same time, how to ensure the quality of mediators? There is a provision for registration of mediators, there is a provision for accreditation of mediators, but all that can be done only once the Mediation Council of India is established. Mediation Council of India has not only been entrusted with accreditation, registration, etc., but training and spreading education as well. Second most important aspect would be even in commercial litigation alone. There is a lot of commercial litigation with the government, especially the PSUs and other governmental agencies. Unless we notify section 49, now this kind of what you call policy paralysis that grips the officers, they don't come forth, and they have some or the other kind of a fear in coming forth and getting into the negotiation or getting into the kind of mediation process. Setting up an internal process of settling the dispute that needs to be differentiated between from the mediation. Appointment of an ombudsman or a kind of a nodal officer, these are all processes to further facilitate mediation. But unless and until in case of a dispute, the government officer comes forth and takes a decision without any fear, perhaps the mediation, so far as government disputes are concerned, will not achieve that much success which we expect by implementation of the statutory regime by this 2023 Act. So this formation of the Arbitration Council, number one, notification of various other provisions of the Act that are very, very essential. So far as the apprehensions in the government sector, PSUs and other government agencies are concerned, they can be very well taken care of by framing the rules and regulations, where in fact it is the government which has been empowered to frame the rules. So all those apprehensions can be very well taken care of by the government. But need of the hour is, especially considering the stress through which our arbitration ecosystem is going on vis-a-vis at least the PSUs in the country at the moment. My view is that this mediation process should be given more fillip so that the concerns of the government sector can at least be addressed, and the time being lost in the litigation in the adversarial system may be saved. It's not only the question of time. So as I said, why mediation is not the question at all, it is not the issue at all. How mediation should be an issue which should be discussed, and the first step perhaps towards how mediation is notification of various provisions of the Act, constitution of the Mediation Council, energizing the Mediation Council not only for registration of the mediators, not only for registration of the other mediation service providers, grant of accreditation, education and training, etc. That's how I conclude.
I will add something more. Brother Upadhyay has pointed out that procedurally and it should be done in the cases when, as I discussed in the partial automation, you people will be aware that it was a case of pre-institution mediation, section 12A, suit was filed, application section 711 was filed, or code of civil procedure. It should be dismissed because of 12A was not complied. So the suit was dismissed. Conundrum arises that when the suit can be saved, in that situation the trial court has passed an order, keep it pending and send it for mediation. High Court confirmed, Supreme Court changed it because they said 12A's language is mandatory. So now this conundrum arises, how it has been dealt with. So that I will clarify. Then in that situation, Yamini Manohar, when it came, then the issue arrived when you ask for a mandatory relief injunction or otherwise, then what would be the situation? Then the court said is merely asking is insufficient. Then this is further clarified in Dhanbad, and in Dhanbad this court, Supreme Court said that the nuance holding that question is not whether interim relief is granted, but whether it could reasonably contemplated by the plaintiff on the standpoint. So this was the overall. So meaning thereby, otherwise pre-mediation litigation is permissible and it ought to be done first, as I am supporting to that extent just as Mr. Upadhyay, and this is the reality.
Thank you. Thank you so much, sir, for your views. May I now move to Honorable Justice Arun Palli. Justice Arun Palli served as a judge of the Punjab and Haryana High Court and is now currently serving as the Chief Justice of Jammu and Kashmir and Ladakh High Court. So there are various hybrid dispute resolution models such as MedArb, ArB-MedArb, which are proposed to be used these days. How do you see the prospects of these models in India?
Thank you, Sonal. Although the question seems short, straight and simple, but in my opinion, it requires slightly a longish answer, of course, within the bounds of the permitted time. So what we are required to deliberate upon is the hybrid dispute resolution models, which combines hybrid mediation and arbitration, offering pathways along the journey to settlement while retaining the final adjudicatory step. The hybrid dispute resolution models represent extremely advanced approaches to resolve disputes that aim to blend the strength approach of mediation as also the arbitration into single integrated process. By integrating these two, the hybrid models seek to resolve dispute efficiently, cost effective and greater party satisfaction. In fact, Sam Kagel was the first to coin and devise this alternate dispute resolution mechanism. It was he who first hybridized the two methods and mechanism. One, the mediation and arbitration, and of course, later named as MedArb, as you said that. And he utilized this for the first time while settling a controversial San Francisco nurse strike in 70s. So MedArb and ArB-MedArb, which is called the changing hat problem, whether the same neutral can act both as a mediator and arbitrator, or whether the both have to be kept, both the roles have to be kept separately, is again another question which is being debated across the globe. So in India, as we move towards becoming a hub for international dispute resolution, So the situation throws up quite a few questions as regards the confidentiality and the fairness of the entire process, and therefore it becomes all the more vital that we develop the clear protocols for Med-Arb and Arb-Med arbitration. Although the Arbitration and Conciliation Act 1996 already provides some facility, as pointed out by Justice Maheshwari, that Section 30 permits that even though the arbitral proceedings in progress, there is a provision to still settle the dispute by way of arbitration. And importantly, this is something worth your consideration, that in Jammu and Kashmir Section 8A is a state-specific amendment which provides a counter, a court-integrated referral mechanism, while during the pendency of the proceedings, be that under Section 9 for interims or 11.6, the court can refer the parties to mediation, and if successful, the settlement can be recorded as an arbitral award. Now, Section 80, as most of us know, of the Arbitration and Conciliation Act allows the same neutral to act as a counselor, conciliator, as also the arbitrator, but of course by express agreement by the parties. Now, this provision, Section 80, has been omitted by the Mediation Act 1923, but since, as we heard in the morning also, that the Act has not yet been enforced, only few of the provisions have been notified, so Section 80 stays as we speak. So therefore, all it says is that yes, the same neutral can act as a conciliator as also the arbitrator, provided the parties agree by a formal agreement in writing. So this shows how Indian law has so far allowed some relaxation, permitting even the same neutral to mediate and arbitrate if party agrees. But yes, insofar as the international models are concerned, the Singapore Arb-Med-Arb protocol uses different neutrals. So they are very strict, and they stick to this and very strictly adhere to this theory that arbitration, if arbitration is paused, mediation is attempted. And if successful, the settlement is recorded as a consent award. And of course, if the mediation also fails, it's back to the arbitrator again. But yes, there is no changing of hats. So this model is hailed as best practices, though in China, the situation is absolutely to the contrary. There they allow the same neutral to act as a mediator, as also an arbitrator, although the settlement rate is phenomenally high. This information is available on the net. But so far as the question as regards confidentiality and the fairness, etc., on an international level, that's quite a concern and is being debated, as I said earlier. But Brazil completely prohibits changing hats altogether. So if at all somebody is acted as a mediator, he's totally prohibited. Rather, he is disqualified to act as an arbitrator, and of course, vice versa. Now, these examples highlight the risks of the changing hat model, and insofar as the Mediation Act 2023 is concerned, then again, you see, this will seek an answer to each one of you sitting here. That Mediation Bill 2021, the draft Section 19, originally allowed waiver of this bar, that if during the course of mediation, the parties have revealed and confided some information with the mediator and somehow the mediation fails and the parties are back to the adjudicatory process by way of arbitration. So there, if at all the arbitrator uses that information while recording an award, of course, it could be challenged by, you see, raising a challenge to the award on that ground. So originally, when the bill is produced in 2021, Section 19, the draft Section 19, it originally allowed the waiver. The parties could enter into a formal agreement and say that the same man can wear the two hats, and they would also sign an agreement that if at all for any reason the mediation fails, there won't be any question as regards the confidentiality is concerned. If later somebody tries to question the award on that ground, that was totally impermissible. But the Parliamentary Standing Committee put its foot down and firmly rejected this. This emphasizes the confidentiality. The Mediation Act 2023, now as we speak, Section 17 provides, now this has completely changed the whole scenario. Section 17 provides that a mediator cannot act as an arbitrator in the same matter. So there's no waiver permitted. Even if parties agree and they enter into a formal agreement in writing in this regard and there is a clause, there's no question the law prohibits it. Section 17 takes care and caters to that situation. So this marks a decisive shift India is aligning with the global best practices, moving away from the same neutral model. So, to conclude, considering the time constraints, the MED-ARB or ARB-MED-ARB efficiency and enforceability, but without safeguarding the risk undermining trust. The Mediation Act 2023 has rightly placed confidentiality above convenience. The task before us now is to craft detailed uniform protocols like Singapore's OD-MED-ARB adapted to Indian conditions. Only then India can realize its ambition of becoming a true global international hub for mediation and arbitration. So with this, I thank the organizers, also Justice Maheshwari, for affording us an invaluable opportunity.
I would add one word for this topic, that Brother Palli has rightly pointed out section 17, which is yet to notify, which is not yet notified. But the another part is, if we look into particularly of section 30 of the arbitration, then arbitration, mediation, arbitration. If it is change of mediation, it may come again back to that, and this may be a swift. The another thing is, whatever is in the situation of Singapore, as pointed out in other places, that may be a circumstances in a thought process of the citizens. Here, if we go on that at present, it is a debatable topic, what would be the situation, and therefore probably this section 17 may have been introduced. I can say this much, nothing more. Let us hope that the things may go in a right perspective.
Thank you so much, sir. This is very informative. May I now move to Honorable Justice T.S. Chauhan. Justice T.S. Chauhan is the serving Chief Justice of the Jharkhand High Court and has also served as a judge of the Himachal Pradesh High Court. Sir, in this age of technology, online dispute resolution system is much discussed. Sir, if you could share your views and thoughts on the practices, challenges, and scalability of online dispute resolution mechanism in India.
Thank you. Good evening, everyone. Online disputes resolution, which I will be referring to as ODR, has emerged as an innovation that promises to democratize access to justice. It's not merely a technological add-on to existing mechanisms. It represents a paradigm shift in how we think of dispute resolution itself. It defines questions of time, space, participation, and enforceability. But then technology is a double-edged sword, as they call it. So I'll be delving on what are the best practices. I've culled out about 9 of them. They could be far greater, many more. To harness the full potential of ODR, certain best practices are essential. 1, user-centric platforms. Interface must be intuitive, multilingual, and mobile-friendly. In a diverse country like India, inclusivity must be built into the design, ensuring even the first-time users feel confident. Second, hybrid models. While technology can automate routine tasks such as scheduling, document sharing, and even initial screening of cases, the human element, that is mediators and arbitrators, remains central. A balanced hybrid model builds both efficiency and trust, as Justice Palli said. Then third is capacity building. Training professionals in both legal and technological skills is vital. Mediators and arbitrators must learn to navigate digital tools. On the other hand, technologists must understand the nuances of dispute resolution. Fourth is legal recognition and enforcement, which is very vital. Parties must be assured that agreements and awards emerging from ODR are binding and enforceable, just like those in offline ADR. Clear legal frameworks under Arbitration and Conciliation Act and judicial recognition are vital. Next would be transparency and accountability. Standardized procedures, clear fee structures, and defined timelines should be adopted to instill confidence amongst the users. Sixthly, integration with institutions, courts, tribunals, and regulators must actively interrogate ODR into the processes. A seamless handoff between traditional systems and digital platforms will build credibility. Seventhly, neutral and impartial processes. The credibility of ODR depends on trust. Parties must feel that mediators, arbitrators, and even automated systems are neutral. This requires transparent algorithms, well-trained neutrals, and clear ethical standards. Then flexible and tiered mechanisms. ODR should support a variety of resolution types like negotiation, mediation, arbitration, or even hybrid processes. Best practices recommend tiered dispute resolution starting with negotiation, moving to mediation, and escalating to arbitration if needed. The next is data security and compliances. Platforms should comply with existing data protection norms, including the Digital Personal Data Protection Act. Encryption of two factors authentication and robust audit trails should be built into the system. Dealing with confidentiality and challenges, these are at the heart of the ODR, but it faces digital risk. Cyber attacks and data breaches threaten sensitive information. Metadata may be inadvertently reveal details unless deletion policies are enforced. Cross-border disputes face conflicting data protection laws, complicating confidentiality. Human error, such as using insecure email or storing files poorly, adds risk. To preserving confidentiality, ODR platforms must be embedded securities in their designs, end-to-end encryptions, secure servers, multi-factor authentications. Legal obligation must mandate confidentiality, supported by audits and certificates. Parties and mediators must be also trained to follow secure practices. Trust in ODR depends fundamentally on confidentiality being protected in both law and practice. While ODR provides speed and convenience, confidentiality remains one of its greatest concerns. The challenges could be like data privacy risk. Disputes often involve sensitive business contacts, personal data, or trade secrets. If platforms are not secure, this information is vulnerable to leaks. Cloud storage risk could be another factor, because many Indian ODR platforms use third-party cloud services, and these are hosted outside India and thus not following Indian jurisdictional laws. Cybersecurity threats, hacking, phishing, ransomware attacks can undermine trust in the process. Then fragmented standards, different ODR services, providers may follow inconsistent data protection services. Lastly, trust deficit. Parties may fear that their data could be misused or monitored, leading to reluctance in full disclosure. Then what could be the solutions? Number one, robust encryption protocols, strict compliance with Digital Personal Data Protection Act 2023, independent audits of ODR platforms, awareness programs assuring users about confidentiality safeguards, using of privacy, preserving technologies like zero knowledge, proof of differential privacy in sensitive disputes. They need to prioritize data localization and ensure platforms adhere to Indian privacy laws. As regards scalability in India, ODR is one of the greatest opportunities for India's 800 million net users, which creates unmatched potential, but barriers remain. Digital literacy is uneven. Platforms must offer multilingual support, visual guides, and offline facilitations. Internet access remains patchy in rural areas. Hybrid online systems may be necessary. Institutional capacity is limited. Mediators and arbitrators must be trained in digital tools. Trust is another barrier. Citizens must see ODR as legitimate justice, not inferior justice. Legal clarity is needed to assure enforceability. Government adoption of ODR in contracts and consumer disputes will normalize it. With inclusivity, awareness, and legal support, ODR can resolve millions of disputes annually and strengthen Indian justice system. Lastly, I may conclude that ODIA is not only a tool of efficiency, but a constitutional imperative for access of justice. With the concerted and coordinated effort by government, judiciary, bar, academia, and private sector, ODIA will become a mainstream pillar of justice. Like UPI in finance, ODIA can be India's global contribution to justice. The vision is justice that is timely, fair, and universal, delivered digitally and inclusively. Thank you.
In addition to Mr. Tarlok Singh ji, Madam Justice, I have certain word of caution, which is online dispute resolution ODIA, the difficulty which we have faced and due to which probably I am thinking this policy is still not come. That is, it is vulnerable of data breaches, unauthorized access, cyber attacks, and confidentiality that is required to be done. Probably the government may be thinking of it, or otherwise we can suggest for it.
Thank you. Thank you so much, sir. Now, may I move to Shri K. Gopalakrishna Kurup. Shri Kurup is a designated senior advocate from the High Court of Kerala and is currently serving as the Advocate General of Kerala. So from technology now, let's move on to some global perspective. So taking a cue from what Justice Suryakant said to borrow best practices from the global players, would you like to share your thoughts on the global perspective or international trends or best practices that we may adopt in India?
Thank you. Honorable Chair, distinguished panelists, all dignitaries of the dais, friends. My attempt will be to make comparative analysis of global models, including the Singapore Convention, the European Union, the United States, the United Kingdom, Australia and Singapore, which provides invaluable insights, institutional structure, enforcement and training. Regarding the Singapore Convention of Mediation adopted in 2018 established a global framework for the cross-border enforcement of mediated settlement agreements in international commercial disputes. Although India signed the convention in 2019, ratification is still pending. The primary lesson for India is the absolute necessity of establishing a global standard for enforceability to build a more resilient institutional mediation ecosystem. Turning to the European Union, the 2008 European Union Mediation Directive aimed to help member states create robust legislation and establish uniform guidelines to enhance the legality of mediation in cross-border civil and commercial proceedings. The directive's key insight for India lies in its balanced approach. It encourages the judicial referral to mediation, but stops short of mandating it, upholding the process's voluntary and autonomous nature. This principle is essential when we negative the procedural complexities associated with the mandatory type pre-litigation mediation under our Commercial Courts Act. Furthermore, European Union framework offers two structural lessons. First, despite remaining challenges regarding uniform standards of mediator qualifications, the directive encourages voluntary codes of conduct, offering an excellent blueprint for the newly created Mediation Council of India to regulate mediator standards. Second, the directive ensures that engaging in mediation does not prejudice a party's legal rights by suspending limitation periods. Though we have enacted a similar provision in India, as per Section 29 of the Mediation Act, the same has not yet been notified. Notifying the same will build greater confidence among disputants. The United States presents one of the world's most mature and effective systems, characterized by strong judicial support and a multi-tier approach aimed at reducing the burden and costs associated with the expansion of the court system. The crucial lesson is judicial integration, comes from the multi-door courthouse initiative. This successfully embeds the mediation into the justice system. India's courts must emulate this by strengthening court-annexed mediation at the district and local levels. The US experience also shows the transformative role of lawyers, initially skeptical in the mid-1980s. Lawyers professionalized mediation by developing ethical guidelines and training standards. India must incentivize lawyers and mandate mediation disclosures in professional conduct rules to accelerate adoption. Lawyers, by consolidating mediation, became instrumental advocates and mediators themselves. Moreover, the US model boasts a robust infrastructure with numerous professional organizations and comprehensive training standards, lending critical credibility. The Mediation Council of India must draw lessons from these organizations to develop strong, uniform standards for training and professional conduct. The United Kingdom's Center for Effective Dispute Resolution conducts regular audits and publishes empirical data. India must develop a robust institutional framework for empirical data collection to inform mediation policy. UK demonstrates an effective model of judicial encouragement through the civil procedure rules, using cost sanction to balance voluntariness with pressure to mediate. Australia's New South Wales provides compelling models of legislative support for mediation, such as the Farm Debt Mediation Act. Singapore requires a legal obligation on parties to consider amicable settlement via the rules of Code 2021. India may consider introducing the practice of filing a genuine step statement before litigation. Singapore has particularly pioneered by hybrid processes, allowing the parties to transition seamlessly between arbitration, litigation, and mediation, providing procedural flexibility suitable for complex commercial matters. There is a lack of specific legal mandate in India governing the hybrid alternate dispute resolution model, which creates uncertainty regarding its application. Though authority for the same can be vaguely traced to Sections 30 and 31 of the Arbitration and Conciliation Act 1996. In closing, the analysis of these global models provides the following takeaways for refining India's mediation framework. The Mediation Council of India must draw lessons from successful US professional organizations to set high, uniform standards for mediator training and conduct. India must focus on promoting mediation through judicial encouragement and lawyer incentives, as is seen in the US and European Union, to foster a voluntary and robust mediation culture. We must foster partnerships between courts and mediation institutions, following cues from Singapore and the US to establish a seamless referral system and improve efficiency. Leveraging global experience, especially the extensive online dispute resolution platforms of US and the European Union, will allow for tech-enabled mediation to reduce costs and significantly expand access to justice across our vast nation. To conclude, by adopting these critical lessons on enforcement, regulation, professional standards, and judicial integration, India can ensure its new mediation framework is not merely compliant, but truly world-class. Thank you.
Thank you so much, sir. Now, may I request to Honorable Justice Girish Kulkarni. Justice Kulkarni is a judge of the Bombay High Court and had a robust commercial and civil practice before he was elevated to the bench. Sir, it's not only India, but other countries that are promoting mediation as a mode to resolve disputes. Can we have your views on comparative mediation practices, the lessons that we may learn from the Singapore Convention, EU, and the US models, please?
Thank you. Good evening. Honorable Chair, Justice Maheshwari, distinguished dignitaries on the dais and off the dais. Full day we were talking about the mediation
possibly in the domestic perspective. But what would be the situation insofar as the international mediation practices are concerned, and more particularly when we are looking at India to be a 4.19 trillion economy, the fourth largest economy in the world, and the estimate of India reaching the second position in 2038. GDP today, as all of you know, is 7.8%. So in this scenario, when we talk about mediation and the resolution of disputes in regard to cross-border transactions or agreements, I think the topic definitely becomes significant and important from the international perspective. Now, we have seen that in the Mediation Act, there is a definition of international mediation in section 3G. But if you see the corresponding provisions of the Act, there does not appear to be much which we can take insofar as the international mediation is concerned. Now, three options are given about what is the situation of the Singapore Convention, the practices in the European Union, and in the US models. Now, insofar as the Singapore Convention is concerned, we are all aware that United Nations Convention on International Settlement Agreement resulting from mediation, popularly known as the Singapore Convention, was conceived in 2018. It was adopted by the General Assembly of the United Nations in 2018, and 2020 it was brought into force. 59 countries so far have adopted the Singapore Convention. 19 countries have ratified the same. However, although India is a signatory to the convention, but we have not ratified it. This definitely has certain consequences when it comes to the mediation and the settlement of disputes in the international scenario. 2026 is going to be the year where Brazil also is ratifying, has already ratified, and it will take effect. Now, coming to this, what is the whole intent and purpose? It is considered to be a very significant achievement because it is based on the New York pattern, as we have seen in the Arbitration and Conciliation Act, the New York Conventions on the UNCITRAL model. It's a landmark treaty providing for a uniform legal framework for enforcement of a mediated settlement across borders. It would definitely facilitate international trade and commerce. The whole perspective is to have confidence of the businessmen dealing with international trade and disputes which may possibly arise, which are required to be settled. Confidence of the businessmen, therefore, and certainty are the basic principles which are actually cherished under the Singapore Convention. Now, there are some drawbacks, possibly in respect of family settlements it is not applicable. It is not applicable in respect of employment disputes. Somebody is working abroad and the country which is ratified this, he may not be, or he or she may not be in a position to take advantage of any settlement. And in any case, because we have not ratified it, there appears to be definitely some disadvantage. Now, coming to the EU model, in the European Union, the model has been there in existence since 2008. The Mediation Directive 2008 has been adopted by the EU countries. It is integrated into the civil justice system, applicable to cross-border civil and commercial disputes within the European Union. Significant feature is that the judges have a right, as we don't have it under our, either under section 89 of the CPC or even under the Mediation and Conciliation Act. But under this model, the judges have a right to invite the parties to mediation and issue an order that you have to go for a mediation, which is something which is significant. Now, member states would be required to establish a mechanism for enforcing the mediation settlement agreements. So that liberty or that free play in the joints has already been conferred. what is the ultimate, the ultimate conclusion is that assuming that there is a mediation and there is a settlement which is brought about, it is in the form of a consent decree. Although the period of limitation is saved as we have in our act, but the problems which arise in respect of the consent decree being executed definitely are existing, and it may quite possibly lead to litigation. Confidentiality is one of the aspects which is also a matter of concern, and it has been specifically thereafter provided that it cannot be used in subsequent proceedings, which is a safeguard which was subsequently brought. It is a full voluntary model as far as the EU is concerned, has made it not very successful because of the complete voluntary nature of the scheme which is in operation, as there are no sanctions or obligations for a failure to mediate. Now this is the situation in the EU. They are not somehow accepting the Singapore Convention in the fullest form because of certain issues in regard to that they are not comfortable, it says one of the articles, they say that they are not comfortable with the nature of the mediators who would be available in the international scenario, and as we discussed in some of the sessions, whether they would be persons of that expertise in handling such disputes. The third model which is put up for this discussion is the US model. Now the US model possibly is more US oriented, I would say. It is a multi-tiered and fragmented landscape for mediation because of the federal nature of the laws in the US. However, at the federal level, Federal Mediation and Conciliation Services is a body which has been constituted, which is a specialized independent agency which would look into such disputes and which would guide parties to come to such settlement. Now, which is focused also on preventing and resolving labor management and such categories of disputes, which is nationwide because it is a federal agency. In 1998, the US federal laws conceived a civil litigation which is known as the ADR Act of 1998. The court is free to devise its own mediation programs under the said act, and the ultimate result would be a consent agreement which is entered between a agreement which is entered between the parties, like consent terms. The consent terms possibly on many of the occasions they go for some kind of disputes even on those consent agreements, and they are challenged on the basis of the argument, the pleas which are available of fraud, duress, mutual mistake, etc. But ultimately it becomes a costly affair. So comparing all these three models, in fact it appears that we are not in a very, we are in an advantageous position. We have all these laws which are already seen on the global perspective, and we can bring in changes so that we can adapt to the international model, and possibly in future India may also embrace the Singapore Convention, which would make us more compatible, and once there is a definition of the international mediation already in the act, I think there is definitely a good way forward. Thank you.
Thank you. I will add for Mr. Kurup as well as Girishji. Girishji has emphasized rightly Singapore Convention, EU and US model. But overall one thing still remains, that that topic would cover by Archana ji, that how we should be, how for international trade and investment mediations, we are thinking how the India can be of this, and for this, for Singapore, ratification required. EU, cross-border, certain their policies are there, so they can go abroad. And so far as US is concerned, it's not fruitful. I do also concur of the same, but here some grey line area, what we have to make the India as a hub. And
Thank
yes, Sunil. Let Sunil first.
Yes. May I now introduce Srimati Archana Pathak Dave. She is a senior counsel designated by the Supreme Court of India and is now serving as the Additional Solicitor General of India. And I may extend the same question with Honorable Justice Maheshwari has extended to you. Since we are speaking about how to improve mediation in India, your views on how we can make India a hub for international mediations, ma'am.
Thank you, Honorable Chair and Sunil, for putting this pertinent and pointed question to me. Honorable Chair, Co-Chair, distinguished panelists and dignitaries of the dais. Well, when on all fronts India is shining and wading its way through the pinnacle, then why not mediation? And the question that I ask is that if not today, when? And if not now, and how? Today we can see that India is emerging as one of the fastest growing economies, has projected to the world its ambition through Make in India, Atmanirbhar Bharat and Viksit Bharat. Trade and investment are no longer confined within national borders. They are the bloodstream of a globalized economy. We know that due to the investor-friendly foreign direct investment policy, under which most sectors are now open for 100% FDI through the automatic route, FDI inflows have been on a very steady rise. The figures are before me, and I can say that it's almost 40% increase now from US $71.28 billion in FY 2024, 23 and 24, as compared to financial year 2013 and 14. Litigation, if we see, is too slow at times. Even arbitration, while effective, often proves adversarial and costly. Mediation, by contrast, embodies speed, confidentiality, and collaboration. It is no longer now a soft option. Rather, it is becoming the preferred global standard. That is the new grammar of global commerce. The time has come for India to embrace not merely the practice, but the leadership of international trade and investment mediation. Well, if we see the global landscape, the adoption of the Singapore Convention on Mediation 2019, which we just talked about, has been a turning point. For the first time, cross-border mediated settlements have been given international enforceability, much like the New York Convention did for arbitration in 1958. Singapore and Hong Kong have already leveraged this, building brands as global mediation hubs. The European Union, too, has embedded mediation into its legal and commercial architecture. Well, we are talking about India as emerging as a next mediation hub. Let me tell you the three major strategic advantages that India has. The first being the geography. Located between the world's two largest trade routes, the West and the East. Whether it is energy from the Gulf, goods from Europe, or technology from East Asia, India sits as the natural crossroads of trade flows. Number two, the market scale and cost competitiveness. With 1.4 billion people and a thriving manufacturing and services sector, India is both a producer and a consumer, making it indispensable in global supply chains. India also offers the world-class professional services at significantly lower costs than Singapore or Europe. Number three, and most important, legal infrastructure and judicial backing. Reforms in arbitration and commercial courts have been deepened by the Mediation Act 2023, which places India firmly on the global ADR map. Indian courts, including the Supreme Court, have consistently encouraged ADR, lending institutional legitimacy to mediation. Put together, these advantages make India not just a participant, but a potential leader in global mediation. Let me now, since the time is short, I'm just skipping the Mediation Act. There is much talk that has happened on the Mediation Act 2023. However, I would like to stress on the opportunities for India and why they are immense. One, the regional leadership. India can emerge as Asia-Pacific mediation hub, complementing but also competing with Singapore and Hong Kong. Investor confidence. A predictable, neutral and enforceable mediation framework lowers investor risk and boosts inflows. FDI magnet. Strong ADR systems are today as critical to investment decisions as tax regimes or labor laws. Institutional growth. Establish a flagship India International Mediation Center on the lines of SIAC. Capacity building. Develop a cadre of mediators trained in trade, investment law, multilingual skills, and cross-cultural negotiation. Digital platforms. Harness India's IT strengths to pioneer secure, scalable online mediation platforms, accessible even to SMEs in cross-border trade. And last, not the least, I propose 5 steps how we can achieve this. One, of course, we have signed the Singapore Convention, but to ratify the same with suitable modifications. Number 2, embed mediation clauses in future bilateral investment treaties, BITs. Establish and train specialized panels of mediators in trade and investment disputes. Develop PPP-based mediation centers in commercial hubs like Mumbai, Delhi, Bangalore, and Hyderabad. Once all these are done, we could have a campaign like Resolve in India, positioning India as a trusted destination for mediation. Thus, mediation is not merely about resolving disputes, it is about building trust, ensuring predictability, and strengthening diplomacy through commerce. By embedding mediation in our economic architecture, India will not just ease its domestic burden of litigation, it will project itself as a nation that is fair, neutral, and reliable to investors worldwide. Arbitration gave us recognition. Mediation can give us global leadership. And I, being a very positive person, I believe that while we see that so much of work is already done in this direction, our judiciary and government, they are both at the same level when we are talking about mediation. So therefore, I feel well begun is already half done. Thank you very much.
I will not, for a lighter side, you are listening for long time. So I will only say, Learned Attorney General is sitting, hearing, ASG, Additional Solicitor General, seriously thought it. I can only say one line, that Indian judicial system is being recognized one of the highest pedestal globally. I can say this much.
Thank you so much, sir. Thank you so much, ma'am. May I just now move to Honorable Justice P. Sam Koshi. Justice Koshi is currently serving as a judge of the High Court of Telangana. He has previously served as a judge of the High Court of Chhattisgarh, which is his parent High Court. So, the concept of community mediation has been introduced in the Mediation Act 2013. May I have your views on how this community mediation is different from normal mediation process, and how can it be effectively implemented in India, and if there are any international best practices that we may adopt?
To answer Sonal's question, it has to be divided into 3 parts. First is the difference between the normal mediation and the community mediation. Second part is what are the steps to effectively implement the community mediation, and the third part is some of the best practices followed internationally. The first one being the difference, though it's a question which is more subjective in nature, but to put it broadly, I will say a few of them are: first, the focus. A community mediation normally focuses on the grievance. It is not always on disputes. A community mediation focuses on resolving the grievance that can affect the peace, the harmony and the tranquility of the community or locality. Whereas the normal mediation normally tries to resolve a dispute between two of the parties. Second being the selection of a mediator. In a community mediation, now under the Act of 2023, Chapter 10 deals with it, there has to be a constitution of at least 3 mediators being there in a community mediation. Whereas under the normal mediation, it has to be a mediator appointed by the parties themselves. The third being the process of mediation that is adopted by the community mediation, which is totally informal, unlike the normal mediation. Community mediation is mostly informal and also very flexible, recognizing the importance of the traditional practices, the customs, which otherwise does not have the following in the normal mediation process. Last is the accessibility. Community mediation provides a forum for resolving the grievance that is accessible to all the members of the society, particularly in the rural areas where the formal justice systems may be too limited. Whereas the normal mediation is also applied to urban and also in the major cities as well. The second aspect was the steps to be taken for effective implementation of the community mediation. In my opinion, there has to be an awareness and education campaign which needs to be taken at the first instance. There is a need for conducting awareness campaigns and provide comprehensive training programs for mediators, lawyers and the public to promote understanding and utilize the community mediation. Just to put the statistics so far as the state that I am representing, in the state of Telangana by now we have trained more than 500 lawyers across the state representing the different bar association. We have been calling the trained mediators to the different district headquarters and training the lawyers at the respective centers. We have more than 150 judicial officers who have got the training imparted. We have got a few retired judges of the High Court who have also undertaken the mediation and are also seriously pursuing it. The next aspect to be taken for the effective implementation is the institutional framework. There is a need to establish well-supported institutional mediation centers that can provide accessible and reliable mediation services. So far as the state of Telangana is concerned, we have around 49 mediation centers across the state. And in the last 1 year, with mediation being taken quite seriously by the state of Telangana as also by the High Court, we have by now resolved around 2,000 matters up till September 2025 in last 1 year time, starting from 2024. From the time the campaign for mediation for the nation had begun, that is from July 2025 to September 25, we have settled around 381 matters by way of mediation. So far as community mediation centers are concerned, in all around 586 matters were referred, of which 356 matters were settled by way of community mediation in the state. Another aspect which has to be necessarily taken care of for the effective implementation of community mediation is there being legislative backing, strengthening of the legislative framework governing the community mediation, drawing inspiration from the international best practices also have to be taken care of. The new act has been enacted from 2023. Chapter 10 has been envisaging community mediation. So we believe that the process of community mediation would fast catch up. There has to be a grassroots level implementation also. This can be done by leveraging the community members as mediators and promoting the dispute resolution in the local within the local communities itself. Some of the international best practices that can be adopted is one that is adopted by the Singapore Convention on Mediation. India's ratification to this convention would definitely strengthen its position in international dispute resolution and facilitate the enforcement of mediated settlement agreements across borders. United Nations guidance on effective mediation also gives an importance at this juncture. Impartiality, inclusivity and the national ownership in mediation processes, providing valuable insight for the India's community mediation initiatives. Some of the indigenous community conflict resolution systems adopted across the globe is one that is adopted in San Francisco, where there is a community boards program. This program employs volunteer mediators who receive specialized training in handling a variety of neighborhood disputes. These community volunteers develop skill in conflict resolution, active listening and facilitating to help neighbors address issues ranging from noise complaints to property boundary disputes. This grassroots approach makes justice more accessible, reduces the burden on formal court systems, and helps preserve relationship between neighbors by providing non-adversarial forum for resolving conflicts. Similar is a process which has been adopted in Brazil, which is known as agentes comunitarios. This community serves as local mediators in areas where formal judicial system have limited presence. These trained community members help resolve neighborhood disputes, family conflicts, minor civil matters through culturally appropriate mediation techniques. They navigate complex social dynamics with an intimate understanding of local norms and relationships, providing accessible justice solutions that prevent conflicts from escalating to violence. Similar is the Singapore's community mediation centers. These centers exemplify culturally sensitive dispute resolution in a multi-ethnic society by employing mediators trained in cross-cultural communication and conflict resolution techniques. These centers provide accessible mediation services that respect Singapore's diverse ethnic, religious and linguistic backgrounds, ensuring that cultural nuances are understood and honored throughout the mediation process. In Australia, there is an Aboriginal tribe known as Dadidri. It is an indigenous Australian community where there is a practice of deep listening that creates space for reflection and mutual understanding between individuals. This contemplative tradition emphasizes patient, quiet attentiveness that allows participants to fully hear each other without interruption through thoughtful consideration rather than reactive responses. By encouraging participants to truly listen to one another's perspectives, this practice fosters empathy and connection, ultimately facilitating more meaningful conflict resolution that honors the wisdom and experiences of all involved. Likewise, there is also a community in New Zealand which is called as Mari Hui. These are formal community gatherings guided by customary protocols that create a structured space for addressing conflicts or grievances. During these meetings, each participant follows established speaking rituals, with elders often facilitating proceedings. The format emphasizes respect, active listening, and collective decision-making, allowing all voices to be heard while maintaining cultural values that social bonds within the community. These are some of the practices that are followed across the globe, which can also be kept in mind by this group of gathering that we have assembled over here when we go back to our respective place, pondering how to develop the community mediation aspect. Thank you.
I will put one example and then I will request how is peripheral area must be increased. Right, brother OC has rightly pointed out about the state. We hope that every state is doing well. I put an example of a community mediation in the state of Madhya Pradesh. What happened in tribal community? There is a tradition that when the boy and girl who are major having some affection, then at the time of Holi, they have one function 2-3 days prior, and 3 days probably he may also aware of this fact because he originally from Chhattisgarh. Then they organize this function Bhagoria, who are having affection and they go with each other, then they come and by way of community mediation, they resolve this dispute and finalize that. And otherwise that will go to the court, meaning thereby pre-litigation, pre-institution, this community mediation is one of the successful example there. But this is not merely an example. We have to enhance it on every aspect and in particular in commercial litigations globally. So this is our issue which I want to convey. Now it is on the...
So thank you for these remarks. With the permission
At the
of
last
the chair,
I can put my all panelists, if they wish to say within 30 seconds any of the mantra, thereby this mediation can be successful in India, that can globally enhance, can they put, we can give an opportunity from Girish starting.
The mindset to have resolution of disputes by mediation would be most important, I feel. The mindset of the lawyers, all stakeholders, it has to be very positive and progressive in the approach to embrace the settlement of disputes by mediation. Now it would take little time, but I think the moment is already gathered and I see a very bright future for this.
Brother Trilokes.
If ODR can be adopted in a far-flung area of Tabang in Arunachal Pradesh, so it can be replicated and imitated throughout the country.
Brother Upadhyay.
Mediation, in my view, can act as an alternate to arbitration, provided we have properly registered, accredited individual mediators and the service providers. So government needs to act. That's my request to Learned Attorney General.
Brother Palli.
On although there is a lot to say, but I say that a successful mediation must be preceded by a definite mindset change, and only then it works.
Brother Kosi?
So far as the campaign that I was stressing on, the first thing that needs to be done is to carry it to the schools, colleges and all the educational institutions, highlighting that there is this mode which needs to be adopted first before going into for any other litigation.
Archana ji?
I feel that community mediation is a really important thing that we must really stress upon, because that's what we have been seeing traditionally also. So if that is nurtured well enough, I think it can be really successful.
Kurup ji?
As suggested in the earlier round of discussions also, that the need for mediation as an alternate, as a tool for alternative dispute resolution scheme will be included in the curriculum in all universities in the who are undergoing law graduate courses, and that also will help us to train better mediators in future.
Thank you. Thank you so much, sir. I would like to specially thank our chair, Honorable Mr. Justice J.K. Maheshwari, co-chairs, Honorable Justice Upadhyay and Honorable Justice Arun Palliji, and all the panelists, and the entire audience for being so patient at this hour of the day. Thank you so much. And with the permission of the chair, may I close this session, sir? Thank you so much.
Good evening, distinguished judges. May I now request